In today's episode, we're going to cover what an actual NDA looks like. So we'll actually go through a non-disclosure agreement together. So let's do, and this is going to be a unilateral non-disclosure agreement. I have an example non-disclosure agreement up already that I wanted to go over with you guys. Gonna zoom in a little bit. Cool. So basically, like most agreements, what starts with are parties. So there's parties involved, right? So if we go down, we have a disclosure party and a promisor party. So the disclosing party, in the situation where I am looking for Victoria's services, but need to tell her about my secret, what was it, the XYZ process? Is that what I called it? Yeah. So I would be the discloser, and then Victoria is the promisor. So the promise that Victoria is making to me is that she's promising not to disclose any of the information that I share with her. So any of the confidential information that I share with her. So that's her promise to me. So I'm the discloser and she's the promisor. So basically, I would put my information. So if I were we can actually do it together. Why not? So let's just say my company. And this is a California limited liability company. And I'm going to have my address. I will say this is actually my legitimate, our legitimate business address for this LLC. And we're going to go to Victoria. I'm going to not share that with the whole world, Victoria. I'm going to say, let's just say you also have a LLC. And let's say that your LLC is at 123 Lane, San Francisco. I forgot the city here. Whoops. All right. And let's say we're going to do business today. Okay. So there we go. All right. So again, so this language is, I like to use this language because it makes it very clear what we're doing. So I have a company and I'm coming to Victoria, and I am going to be disclosing confidential information to her, and it's for the purpose of exploring potential business relationships between us, right? So there might be a business opportunity where I can pay Victoria and Victoria's company to do something for my company, right? But I need to tell her about my secret XYZ process in order for us to even get to the point where she can evaluate it and tell me, hey, I can do A, B, and C for you. Or she can say, you know what, actually, sorry, I don't have the resources right now to help you do what you want to do. However, even though I can't help you, I promise that I'm not going to disclose what you told me, the XYZ process, to anybody or use it for my benefit. So this talks about possible acquisitions of also assets. So I'm also, if Victoria maybe her company is really successful, she might actually say, hey, you know what, actually, how about I just purchase your XYZ know-how for the XYZ process from you? So these are all possible business outcomes that might occur from me disclosing and sharing my XYZ process to her. Now, again, so we have certain trade secrets and business information that's proprietary to me. So my XYZ process. So I'm just going to annotate this for you guys, just for clarity. All right. So proprietary information, that includes all information that is not known by actual potential competitors or is generally unavailable to the public or otherwise confidential. So what does this mean? So what this means is that if my XYZ process is actually already out there in public information, then it wouldn't technically be covered by this agreement because it wouldn't be proprietary information. If it was generally known, in other words, if it was in a journal paper, for example, maybe I already published it in a journal paper, or if I somehow disclosed it already to someone else and that person somehow published it in a paper or put it on a website blog, then it would no longer fall under this proprietary information paragraph, right? Because it's no longer, because it's generally available to the public. So this assumes that I've actually taken steps to maintain the confidentiality of my secret XYZ process. So I've limited access to who knows about it on my team. I've taken precautions not to, of course, not to publish it, not to post it on a blog post, not to post it on LinkedIn, not to tell anybody about it that hasn't signed a similar type of document. So I've taken steps to try to maintain its confidentiality. That's very, very important because of this sentence, really, right? Because it's not known and not generally available. Now, the second clause is saying that, so information that has been created, discovered, developed, or otherwise become known to the disclosure. So this is basically saying that if, let's just say Victoria hypothetically developed the XYZ process independent of this, right? So if she's already developed an XYZ process, but she calls it the ABC process, but it's actually this exact same process, then this also would actually protect her, right? Because this is basically saying that if she independently developed it, then she wouldn't obviously have to keep her own proprietary information confidential, right? And then it's really important that this third paragraph has economic or potential economic value to disclosures present or future business. This is really important. So in order for it to be, and this is really what a definition of a trade secret is. So it has to derive independent economic value, right? So if my XYZ process doesn't actually yield any economic, so if it doesn't have any value, if it's just a cool thing, but no useful utility that can actually generate revenue for a business, then theoretically, it won't qualify as a trade secret under the California Civil Code or even under the federal Defend Trade Secrets Act. So what these clauses here are actually showing us they're actually covering what it is to be a trade secret. So now this calls out variations of what this XYZ process and what form it might come in, right? So it can be process. So most likely it's going to fall under this clause here, process. So all discoveries, developments, designs, improvements, inventions, formulas, software programs, patent applications of disclosure, subject to non-publication, elections or restrictions, processes, techniques, know-how, data, research, techniques, technical data, customer and supplier lists, and any modifications, enhancements, or improvements to or of any of the foregoing, and all program marketing, sales, and other financial or business information disclosed to the promisor by the disclosure, right? Either directly or indirectly, in writing or orally, or by drawings or by observation. So this is really all encompassing, but it's information disclosed to the promisor by the disclosure. That's sort of the key of this agreement, right? So all proprietary information that I somehow communicate to Victoria would be covered by this agreement. So let's see, this is covering confidential information again. And it's a little more expansive because this is also talking about tax records or financial information. Now, why do we include language like this? Well, sometimes some of the know-how involves finance, and it could possibly involve financial aspects of my business, right? And so that we want to keep that and maintain that confidential. Like I don't want Victoria going out and talking about my margins or other sensitive business information, right? Because if my competitors got a hold of that information, it could jeopardize my business. And again, this is really the key paragraph right here of what actual non-disclosure. So this is the part that Victoria is going to have to do, which is, in other words, is to keep it in strictest confidence. So this section of this non-disclosure agreement, or this example of non-disclosure agreement, explains all the things that Victoria promises to do. So she promises to keep it in the strictest confidence and not to disclose to any third party. Now, let's talk about this for a second. So what's a third party? So a third party could possibly be another business that Victoria is doing business with. So she can't take the information that I give her and then tell one of her clients about it, right? Because that would be at a third party. Now, would a third party, now an employee of Victoria that's also under a requirement to maintain confidences, and actually what we might do is we might have her employees also sign something similar if it's really sensitive, right? But they would no longer be a third party once they sign the agreement, right? And this section here is talking about the fact that she can't reverse engineer or disassemble the confidential information that I provide her. And so we don't want her doing that. We don't want her trying to take it apart and trying to reverse engineer it. This third section here is saying that we don't want her to help any third party use any of the information that I disclose to her without my express written consent. So that would be the example that I just described where she tells a client about it or a potential business partner about it, right? If she does that, she can do it, but she has to get my express written consent. And again, this rest of the language here is talking about the fact that she has to maintain it's confidential as long as it's not generally known to the public, or if she developed independently or someone else told her about it, not for me. So if Victoria has a client that also developed XYZ process and told her independently of me, then again, this no longer would apply. So very, very important. That's why it's so important to try to keep your confidential information confidential, right? Because if I disclose it to a third party without having this agreement in place, and then they tell Victoria about it, now it's no longer covered. It's no longer protected because I didn't take steps to keep it confidential. I disclosed it to a third party without having them sign this agreement, and so now it can be considered to be generally known and generally available to the public. And that's exactly what this is saying. So, or becomes known to the promisor through disclosure by third parties not under an obligation of confidentiality. And that's exactly the situation that I just described. So if some third party independently develops it and tells Victoria about it, or if some third party acquires the information, maybe even from me, but I have a bad day and forget to take these steps to require them to sign an NDA, that would effectively end the proprietary information, and I would Victoria would technically no longer be bound by that. So it's very interesting. This is basically saying that if Victoria is subpoenaed, so by a court, that again, I need reasonable written notice, and I need an opportunity to tell the court, hey, you know what? I object to that. I don't want the court to have my confidential know-how. This is a really important clause. So this is saying that she's also going to try to keep it confidential. So if I provide her with confidential information, she's going to keep it under lock and key. She's going to password protect it. She's going to take steps to also avoid third parties obtaining it or having access to it, right? So if my XYZ process is super valuable, there might be people that might be snooping around trying to get the information from Victoria. So Victoria also agrees in this agreement to take steps to maintain its confidentiality and not allow third parties to gain access to that confidential information. And then if for some reason it is appropriated by a third party, or if she accidentally discloses it, she's going to tell me, she's going to bring it to my attention immediately. So you're going to bring it to my attention. So you're going to notify me promptly of any misuse or misappropriation of the confidential information or proprietary information. Now, this sentence talks about future assignment of inventions. So let's just say that in the course of our XYZ process, if Victoria develops it out into an actual product, she agrees to assign her rights in that invention to me. So this is actually really powerful. Victoria's going to have to think about if she wants to sign this or not, right? Because if she ends up doing this, I'm going to own everything that she develops. Obviously, in this business relationship, in this hypothetical, she's going to be compensated for it. But she really needs to think about whether or not she wants to sign something like this, because this is actually really strong. She's agreeing to assign her inventions that arise from this. So if she develops out a product using the XYZ process, I would theoretically, if she signs this, I would have rights, any patent rights to that invention. And this is saying that she agrees to basically sign any assignment. So if we do decide to file a patent application on the work that she does in the future, and I email her an assignment, she's saying she's agreeing in this agreement that I'm going to sign it, so that to your company, so that Standard Technology in this example is going to own all patents that derive from this invention. So really powerful stuff, guys. A lot of the rest of this agreement, I don't think we really need to go over, but basically it's just saying that, so this section here is covering control of actual equipment and information that I supply her. So paper, digital files, and all that. So it's saying that it's my exclusive property, right? So at no point in time is it going to belong to Victoria. And she agrees to return it, so deliver promptly to me. So again, the rest of this language is pretty standard. So she can't assign it. So she can't assign it to third parties. This is saying that, so she can't license it. So in that situation where she has a patent, this is not a license. I will outright own it. And again, governing law, this is important. So if Victoria's out of state, she's in Nevada, I'm going to want her to sign in California. Again, she has to think about that, because if there's a conflict, she's basically agreeing to be sued in California. So if I have to enforce this agreement against her, she's going to have to come to court in Nevada. So governing law, this is very important. It's something to think about. I don't know, Victoria, do you want to have to fly out every time? I mean, not that you would disclose my confidential information, but it's still something to think about, right? This makes you subject to being sued in California. This is saying that this is the whole agreement, and basically we can dice it up if we need to. And I don't think we need to go through the rest of this. But the rest of this is pretty standard language. The big thing here is that this entitles you to attorney's fees. So if Victoria, in fact, discloses my confidential information to a third party, and I sue her and I can prove that, then I'm entitled to attorney's fees. So if I win, if I'm the prevailing party, then I'm entitled to attorney's fees, which could be a big deal, because attorney fees could be pretty high. So basically, all the legal costs that I have to pay to prove that Victoria disclosed my information to a third party, I could recover. So pretty powerful. So at the very end, I would sign. So I'm the discloser, so I would print my name here. I would sign here, and then Victoria would print her name here, sign here, and yeah. So that is a unilateral non-disclosure agreement. We can go through a mutual one later. Looking forward to answering many more intellectual property questions for you guys. Thank you so much.